are you going to lead the court with the moral ascendancy?
You know, the face of the Chief Justice is just the outward face of the judiciary.
Yes.
I don't think that, I think that the moral ascendancy of the Chief Justice is not necessarily among his co-equals on the High Court, but rather on those below the High Court. I cannot have moral ascendancy over persons who are equal to me if I was to be Chief Justice. But I can certainly ask them to cooperate, to help me rebuild this very tattered reputation that the judiciary has right now. And I think that all of them will be interested and be concerned in making the judiciary a truly co-equal branch of the government again. Right now, it's in tattered remains.
Okay. This is a question which we received from our Twitter and email at 4:50 this afternoon. Yes. This is a question for Attorney Ligarda. Now, how do you respond to criticisms that family lawyers aggravate the enmity between married couples, causing further conflict?
Actually, I will agree about some family lawyers. Instead of trying to make things easier for the family to go to the court system, some of them really exacerbate the problem. I do agree, which is why when we were preparing the rules for the Supreme Court on mediation, we specifically requested, I specifically requested, and I think Judge Bison and then DCA Vilches specifically requested that lawyers not be allowed during mediation. Because they really exacerbate the problem.
Okay, so it's true.
So for many, yes. I hope it's not true for me. I hope it's not true for me. But for many, yes, I have seen it. I have seen it. They tend to needle their client. And in fact, very recently, a friend of mine who was handling a particularly contentious case was very upset because what the client of the other lawyer did was she went to a third lawyer, you know, and filed something in court. Talk about lack of legal ethics that the third lawyer took it on, knowing that these two lawyers were already talking and about to enter into an agreement. So yes.
Okay. Now this is the second question. It's a fact that there are many juveniles who are engaged or involved in most of the crimes today. Is there a need to reform the laws on juvenile crime and delinquency?
First of all, I object to the premise that most of the crimes today are committed by juveniles. That is extremely not true. In fact, the statistics on juvenile delinquency have not changed. The problem is the investigation of crimes is so bad that it's easier for the police officer to grab a juvenile off the street and add it to the statistics of their crime. Solved, child picked up, change the law because we cannot arrest a child who's below 15 or below. So I don't think, well, we need to implement the juvenile justice law. We need to persuade the local governments that they have to put money into their communities so that they can build separate facilities for the children in their communities who may commit offenses. We need to persuade the local governments that they need to invest money into training of the social workers and training of the police so that it's not true that you don't arrest a person who is 15 and below, you have to take them into custody and have them go through therapy. Otherwise, if you keep letting them go and say, oh, hindi ko ma-arresta yon dahil below 15, by the time that boy or girl turns 18, he's a full-fledged criminal. Because no intervention was done for him whatsoever. So the law is good. I don't think it should be changed. What should be changed is the concept of the police that, oh, it's so difficult to go after adults, let's just go after the child. And the concept of the local government who doesn't want to put the money where the law says the money should be put in.
So my last question, Atty. Ligarda. How do you want to be remembered as the First Lady Chief Justice of the Supreme Court?
As someone who has always been fair.
Okay. On that note, I don't have any more questions for Atty. Ligarda.
Thank you. Thank you, ma'am.
Justice Hermosissima.
Good afternoon, Attorney Ligarda.
Good afternoon, sir.
I have been well acquainted with Attorney Ligarda during my stint in the Sandigan Bayan. She was an active practitioner then.
Yes, sir.
Although I can say that Presiding Justice Garcitorena was always in her favor because they are both of Spanish descent.
I hope that's not the only reason, Justice. I hope he was also in my favor because I always came well prepared to court.
Well, what subject in law is your forte?
Well, right now I teach persons and family law, Civil Law Review 1, Succession and Torts. And for legal ethics and for MCLE, I particularly I teach legal writing and legal ethics, Your Honor.
You realize, of course, that the Supreme Court is a court of general justice.
Yes, sir.
And so you don't specialize in any particular subject in law. Well, first things first. There are objections to candidates for the Supreme Court, the Chief Justice, who are so-called outsiders, United Judges. When Senator Miriam Santiago applied for the position of Chief Justice, I told her that I'm not objecting to outsiders applying for positions in the Supreme Court. Because I told her about Earl Warren, Governor of California, who was approached by Eisenhower, said, if you help me in your campaign, and if I succeed as President of the United States, I will appoint you to the first vacancy in the Supreme Court. It turned out that the first vacancy was Chief Justice of the Supreme Court of the United States, and so Eisenhower said, no, just Associate Justice is not Chief Justice. But Earl Warren said, if you have any sense of honor at all, you will appoint me to the first vacancy in the Supreme Court. And he was. And Earl Warren was appointed. It turned out that the Earl Warren Court turned out the best doctrines in law in the United States. Among them was this Miranda doctrine. That's his. So, considering your forte, Is the same-sex marriage allowed as legally valid and constitutional in the Philippines? This is valid in California, it's valid in Oklahoma, but then
And Massachusetts,
how
I
about
think.
Massachusetts. How about in the Philippines?
No, Your Honor. Because in 1988, the Family Code specifically required a man and a woman to be qualified to marry. Prior to 1988, Article 52 of the Civil Code does not state the gender of the marrying parties. This came into effect under the Family Code in 1988.
Well, others say that it is in accord with human rights on the matter. How about this proposal to teach or sex education among grade school and high school students? This is opposed, of course, by the Catholic Church. What are your thoughts?
You know, Justice, I work with the Child Protection Network Foundation.
Or would you like to leave it to the parents to do it?
Well, the word sex education is not mentioned in the civil law or in the family code as an obligation of the parents. The problem is, Justice, we have one of the highest numbers of teenage pregnancies in the world today. We are almost at par with the United Kingdom, where they have child mothers. And the reason for that, and we are horrified at the Child Protection Network Foundation, that many young children think that they won't get pregnant the first time, which we know is false. Many people do not understand actually what the act of sex is. We have children who come to us saying that they were raped. But when you ask the questions, what do you mean when you say that they were raped? It turns out that maybe they were kissed or hinipuan sila because they see in soap operas screaming, hair being pulled, kissing scenes, and then segueing into something else, and it turns out that a sexual act had occurred. This continued cloak that veils the act is not good, and I would prefer that the schools and properly trained professors take it on, because now what happens is that these children see it on the internet. We had an extraordinary study recently done, Your Honor, that 9 out of 10 children have seen pornography and the act of sex on the internet. And without guidance from both parents and schools, I think the problem is just going to be worse. So yes, I agree that there should be sex education according to the age of the child, relevant and appropriate for the age of the child from grade school up. Our greatest number of victims are at the ages of 13, 14, 15.
On another matter, Congress is now starting deliberations on the RH bill. As a Chief Justice of the Supreme Court, it is only proper that you have your ears to the ground, so to speak, and watch the issues that will most probably come up to the Supreme Court for consideration and judgment. Well, the foremost issue in the RH bill is, will it have to, the Supreme Court will have to resolve whether or not the RH law violates the constitutional provision which states that the state should protect the life of the unborn from the moment of conception. Is the use of condoms or contraceptive device prevent the implantation of fertilized ovum?
Yes, Your Honor. When the Constitution talks about the unborn,
What is your view? Yes or no?
yes, Your Honor, the use of contraceptives, condoms, and did you say the pill, Your Honor?
I didn't say that, but it's part of it.
Sorry. Yes, the use of contraceptives prevents conception. And it is only when there is conception does the provisional personality of the child created. And it is that child who must be protected at conception.
So what is your view?
Well, my view is that the constitutional provision can still be employed in order to prevent damage and injury to a conceived but unborn child. That is where the protection will come in.
Well, on that note, thank you very much.
Thank you, Justice.
Secretary Mosni.
Chief.
Thank you, Attorney Ligarda, for your patience. I believe most of my questions have already been answered by my colleagues here, but I just have one more, if I may. Attorney Ligarda, you are recognized and perceived to be one of the leading champions of women and children's rights in the country today. There are, like Justice Hermosissima has mentioned, there are certain pending bills in Congress that may have direct implications on women and children's issues, which eventually the Supreme Court may be asked to adjudicate. I'd like to ask you, do you have any position on legislating divorce in the Philippines?
I have no position for legislating divorce, Your Honor, because first, we're the only country in the whole wide world without a divorce law. Even Malta, with the Knights of Malta, have a divorce law. Secondly, I don't understand the resistance to divorce, other than that the Catholic Church does not wish it to be passed, because the concept of declaration of nullity is better because there is no recognition that marital bonds exist. The concept of a divorce, I think, may be passed in limited sense. As human beings, people make mistakes. People are coming to family lawyers sometimes only after 6 months of marriage. It is just extraordinary. And you wonder when you look at these young people, 23, 24, 25, what is the life ahead of them if they are not given a second chance? My position on divorce is that it is time for us to have a divorce law. We can use the Article 55 of the Family Code, which are the grounds for legal separation, as grounds for divorce. Instead of saying na ayaw na namin sa isa't isa, so maghiwalay na tayo, which is a no-fault divorce, we don't need to go that far. But I think if you look at the statistics of our Filipino people now, 50% of marriages are in the courts for some reason or another. The Supreme Court itself, I don't know, the statistics of petitions for nullity of marriage coming before the Supreme Court is mind-boggling, and yet the court has actually only granted 7 out of the thousands that have come to the Supreme Court. And the Supreme Court are beginning to apologize for, I'm sorry that you have to live with a person who is so awful as this, but unfortunately, impliedly, your lawyer didn't do this properly. You know, the lack of juridical antecedents particularly is what affects nullity of marriages before the Supreme Court. So these people, forever, they're going to be married. And there is no escape except death. And that is why I always tell men who batter their wives, do not close your eyes at night, because the Supreme Court in the Marivic Henosa case has allowed a woman to kill you in self-defense. So why go to death when there can be an amicable settlement of marital life?
Thank you for that, Attorney Ligarda.
Thank you, sir.
Chair, thank you po.
You were talking about the case, you mentioned about the case of People versus Minerva Henusa. Yeah. I think you were the counsel.
I was appointed counsel de officio
By the Supreme Court.
By the Supreme Court, yes.
But you did not defend the accused before the lower court.
No, Your Honor.
But the Supreme Court said that at that time there was no yet 9262.
None yet, Your Honor.
And therefore, Henusa was found guilty of the crime of parricide, but the penalty was reduced because of the presence of several mitigating circumstances. And the Supreme Court said that there is no yet law recognizing battered woman syndrome as a defense. Is that correct? Am I correct?
That's
Am I
correct,
accurate?
Your Honor. That's correct, Your Honor.
Now, since the effectivity of 9262, which is the violence against women and children, can you recall of any case where a woman charged with the crime of parricide, she was acquitted on the ground that she killed the husband because she's a battered wife? Is there already a case?
Actually, Your Honor, if I may say so, none. You know why?
Yeah.
You know what the police officers do? After they've investigated and found out that she was a battered woman, they don't bother arresting her anymore. It's very interesting phenomenon, that 9262. They don't bother arresting this woman anymore. They don't bother putting her in jail. And they accept hook, line, and sinker that this woman murdered her partner because she had been a battered woman, which we have tried to address with the police officers when we train them, the women's desk. We tell them, you need to still file the case because they need to prove what the Supreme Court requires in the Henosa case, that you went through the cycle of violence at least twice before you can be considered a battered woman.
That's why it's really very hard to get an acquittal.
Yes, I agree.
If you really study the definition of a battered woman syndrome, in that case, you have to undergo 2 cycles, no? Now, my other question is, 90 to 62 is supposed to be protection to women and children.
And their children, yes.
And their children. But there has been some comments that 90 to 62 actually is discriminatory against men, because a man is not entitled to a protection order. But there are also cases where the wife now becomes the beater. So there's now what we call man-battered syndrome.
Agree, Your Honor.
Yes,
Your Honor. Many of my clients were battered men.
What's then the remedy of the battered husband if the 9262 is only for the protection of women and their children?
Well, what I have advised the battered husbands is that 9262 is also for the protection of their children.
Yeah, but
so they can seek a protection order on behalf of their children.
Yeah, for their children.
Yes, Your Honor.
But can the husband get a protection order against the wife?
No.
if the wife is the one causing physical violence, if the wife is the one causing economic violence because the wife keeps the money of the family.
Well, physical violence perhaps...
I'm referring to economic violence. There are 4 kinds of violence under VAUC, and one of which is economic violence. And it's economic violence where if the husband is the one keeping the money and does not want to give the money to the wife, then she can file violation of 9262 on that ground. But if it is the wife keeping the money and the wife does not give the money to the husband, can the husband go to the court and then ask for a protection order from the court? Of course, the husband cannot.
Well, he can go and seek for, he can seek to be made sole administrator of the partnership.
Oh, but that's a longer process.
It's a longer process.
You remember,
He needs-
Legarda,
yes.
that you can even get a protection order before the barangay chairman.
That's correct.
If you go to the regular process, it is longer. In the
That's
meantime,
correct.
the husband does not have money to buy for his food.
That's correct.
Yeah. So do you think that there should be an amendment to 9262?
I do, Your Honor.
Oh, yeah.
I do.
I think I agree with you. It's really
I
unfair
do.
to the men.
Actually, Your Honor, that law was supposed to be the domestic violence law.
Yeah.
What happened was it was changed at the last minute. So if you look at the crimes, may nagging, di ba? Yung nagging,
Oo nga eh.
that's actually addressed to apparently us women.
Kasi kawawang lalaki, even stalking is now a crime under 9262.
Yes.
Following a woman whom you like and love, no? If you persist in following that woman, then the woman might charge you for stalking.
Right.
But
That's
if
right.
the woman is the one following the man because he's handsome, the man cannot file a case of stalking against the woman. Is it not?
That's correct,
Tama
Your
ba?
Honor. That's correct,
So
Your
I think we
Honor.
have to amend the law.
I agree.
Yeah.
I agree.
Now, you were talking also about liability of minor children under 9344. You said that the law is good, no? But if you read the law on the exemption of criminal liability, no, you will find that there is only one instance, or there is only one group of minors who can be liable for the commission of a crime. Is it not? Because under the new law, if the age of the offender is 15 or less, totally exempt from criminal liability, but he will he be released to the custody of the parents, is it not?
And
Or to the DSWD and undergo some sort of reformation. I think it's an intervention program, is it not? Okay. But if the age of the victim is the offender is between 15 and 18, he can still be exempt from criminal liability because in order to be liable, you will now have to establish discernment. And discernment is very hard to establish.
We're the only country in the world with that in our law, Your Honor.
That's why I think there's a need to amend that provision. Because I tell my students that when I was 17, I said, I had already 4 girlfriends. But they did not know that they were my girlfriends, you know. No, seriously speaking, the problem is this, no, under the law. Who determines discernment?
Unfortunately, it's the social worker.
It's the social worker or the policeman.
Well, it's supposed to be
If-
the
if-
social worker, not the police officer,
But
Your
under
Honor.
the law, if the minor in conflict of the law is arrested by the policeman, is it not that the policeman can determine if he acted with or without discernment? Okay.
No, Your Honor, he's supposed
Is
to...
it the social worker?
Yes, Your Honor.
You can just imagine under the old law, when a minor acted with or without discernment, it is the court that determines. Because under the old law, if one is exempt from criminal liability, the procedure is that you have to file a case against the minor. Because the burden of proof is on the part of the accused that he was a minor at the time of the commission of the crime and that he acted with discernment. Is it not?
That's correct, Your Honor.
So do you think that there should be an amendment insofar as this aspect?
Actually, Your Honor,
is
what
concerned?
needs to be added
Yeah.
is a provision on a minor that commits heinous offenses.
Oh,
There's
that's
none.
Yeah, that's
There's
correct.
none. There's none.
That's correct.
And that should be added to the law. In fact, I think baka naligtaan nila or they
Kasi
forgot.
alam mo, sinasabi nila, Attorney Legarde, is that itong mga magagaling na sindikato, no, criminal syndicates, they are now using the minors, those less than 15 years of age, to commit the crimes for them. I think you're aware of these comments from groups like the violence against the group violence against the VAC, for that matter. They want this to be amended. I think there is really to amend that provision.
Yes, that provision. But I think, Your Honor, the Supreme Court is also attempting to kind of address this a little bit when you came out with your new rule on the juvenile in conflict with the law. I'm not sure if it has already been signed by the Supreme Court.
In fact, that was what I wanted to ask you.
Yeah.
Can the Supreme Court remedy the situation by using its rulemaking power to promulgate rules and regulations to address these problems?
Well, the Supreme Court has used it for the rule on examination of a child witness.
Yeah.
The Supreme Court has used it for the rule on electronic documents. The Supreme Court has used it for the rule on mediation and on declaration of nullity, separation of marriages, guardianships. The Supreme Court has used it, in fact, also in the rule on 9262.
Yeah.
You've used it. And I think you can use it, Your Honor, just to address the fact that minors who commit heinous offenses really need to go through a court process.
Yeah, that's correct. That's correct. It should be the court that should determine if a minor acted with or without discernment. It should not be the social worker. Yeah. Do you agree with that?
I agree with you, Your Honor.
So can you make the proposals for the amendment of the provisions later on?
I will, Your Honor.
Oh, yeah. Okay. Thank you very much. On that note, thank you very much, Attorney Legarde.
Thank you very much, Your Honors. I know you've had a very, very long day. You've been very patient with all of us. Thank you.
At yan po napanood natin ang interview sa huling nominee for today. Siya ang ika-anim na nominee, si Attorney